My name is David Truong and I'm Senior Associate at Alliance Compensation and Litigation Lawyers. If you were involved in a motor vehicle accident and injured yourself, you are entitled to statutory benefits, which includes wage benefits and medical expenses to cover both physical and psychological injuries. In some cases, you may also be entitled to common law damages. Medical expenses include consultations with your treating doctor, physiotherapy scans, domestic assistance, and many more. However, the treatments must be related to the motor vehicle accident and must be assessed on whether they are reasonable and necessary. The medical expenses will be covered by the relevant insurer for at least 26 weeks, depending on the severity of injuries and liability. If you had to take time off work as a result of the accident, the lost wages will be covered by the relevant insurer. The insurer will calculate your pre-accident weekly earnings and the difference based on that. If you lodge a claim within 28 days of the accident, you will be covered from the day of the accident. If not, you will be covered from the date you lodged the claim. Your wages will be covered for at least 26 weeks, depending on the severity of your injuries and liability. Under specific conditions, you may be entitled to lodge a common law damages claim, which includes pain and suffering and lump sum compensation for past and future loss of income. One of our clients was involved in a major motor vehicle accident where the car was hit by a truck and pushed along the road. As a result, they sustained significant physical and psychological injuries. We took care of this case and lodged an application for personal injury benefits. Their treatment by the general practitioner, physiotherapist, and psychologist were covered by the insurer. We had no difficulty in establishing that the injuries are considered non-minor. Our client had been unable to work since the accident. Most of their physical injuries have recovered, so they would have been able to return to work without any physical restrictions. However, they remain very unmotivated and depressed. Given their persistent psychological symptoms, we had them assessed by a medical legal psychologist. The psychologist assessed our client as 19% whole person impairment, which would entitle him to non-economic loss damages, also known as pain and suffering. The insurer accepted our psychologist's opinion and the matter was set for an informal settling conference. During the conference, we argued that our client was self-employed since 2008 and it would be extremely difficult to retrain to take another vocation. We also argued that as they could not return to work since the accident, this may be a permanent lifestyle for them. However, we acknowledge that with continued treatment, they will have some capacity to return to work, as they have the capacity to do so. The insurer had no other evidence contrary to our arguments and we successfully settled our client's claim for $407,000 all inclusive. This is a great example of a case where you must have the physical and psychological capacity to be able to return to work. At Alliance and Compensation Litigation Lawyers, we understand all the aspects of the claim. Just because you're physically fit doesn't mean you can work at your fullest potential. If you have been involved in a motor vehicle accident and you think you have a potential claim against the insurance company, please do not hesitate to contact us.